Good morning, students. Good morning, friend lawyers. Today I am going to give you tip 26, Indian Penal Code, joint and constructive liability. What is that mean by? Unless and until you understand these provisions of law, there will not be any proper trial likely to be conducted by you, because if there are more than one offenders, there is possibility of joint and constructive liability. This joint and constructive liability has been directed, elicited, prescribed, provided under section 34 to 38 IPC, 149 unlawful assembly, 396 dacoity with murder, and section 40 housebreaking by night with murder and grievous hurt. What is that joint and liability and constructive liability? Is that liability that you may not done anything, but one of you accompanied with you would have done it, so then you are also liable. That is called joint group liability and constructive liability. A, B, C, D, if went to commit murder, if nothing had happened, but criminal conspiracy was there for punishment. So actually constructive liability is nothing from vicarious liability. Vicarious liability is a servant doing something, agent doing something, the principal or owner has vicariously liability. But constructive liability means joining with the co-accused with criminal intention. That gives you liability for punishment. Vicarious liability is criminalized in exemption rather than the rule, but constructive liability in criminal is a well-recognized principle. So now we will go with the section common intention. Section 34, we will just discuss about 34, and later on I will discuss about the 34 to 38 independently. So, act done by several persons in furtherance of common intention. That is section 34. Act done with criminal knowledge or intention, 35 and 36. Cooperation in acts constituting an offence, section 37. Person concerned in criminal act may be guilty of different offences, section 38. These all are the things you have to understand. See, for example, for this common intention, I would like to take you, if suppose a friend on bicycle going towards one particular place and you are standing there, you asking where are you going? You say somebody has to give me money, therefore I am going there. Then what happened? Both going there. Thereafter what happened? The cyclist wanted his friend to pay the money. When he refuses and abuses, he suddenly wanted to assault him or stab him. Then if the pillion rider remains silent, he is not liable because he is not sharing common intention to assault him. But suppose he holds the person when a cyclist is stabbing, so he is sharing common intention spur of the moment. This is what common intention. Suppose if you are a cyclist, if it's a pillion rider went there and to claim his due from friend, and he assaults him, then the cyclist facilitating the pillion rider to run away from the place, that also is sharing common intention. These all are things we will discuss step by step. So joint and constructive liability must be understood. Section 34 to 35 must be clearly understood from different. Suppose there was a common intention to commit some offense and something else was committed, then you are also liable to for sharing the common intention. This is what Messi means Citria. Best wishes.